folks, and welcome back to Contract Law. This is part 8 in the video series for contents of a contract and exclusions. And in this part we are going to have a look at the notion of exemptions. Now, exemptions in the form of exclusion clauses have been discussed in a couple of different areas in this video series. And we've seen that they can often cause quite harsh consequences where they are effective. Basically, they will exclude or limit liability for something happening. And so what you find is that there are some nice curly questions that arise in terms of how a court will treat exemption clauses. And so there are two forms of clauses here that we need to look at. Mostly the problematic area is mostly exclusion clauses, so where a party purports to exclude liability, any liability for the occurrence of a particular thing. You might also have a more limited form of that where a party purports to cap their liability or limit their liability for the occurrence of a particular thing. So often a party will cap their liability at, for example, the purchase price. We won't be liable for any negligence, for example, except to the extent of the purchase price. So the most you can get back in damages is the purchase price. Courts aren't really worried about those forms of clauses so much. It's really the exclusion clauses that have warranted a lot of attention in the courts, although generally speaking they will both tend to be construed in roughly the same way. So let's have a look at the general attitude of courts towards exemption clauses. So it's relatively clear since the Darlington Futures case, which was a High Court case in about 1986, that the way that exemption clauses will be treated will be, generally speaking, similar to the way that the court will treat other issues of construction. So the High Court there said interpretation of an exclusion clause is to be determined by construing the clause according to its natural and ordinary meaning, read in light of the contract as a whole, giving due weight to the context in which the clause appears, including the nature and object of the contract. And here we have a little rider, where appropriate, construing the clause contra proferentum in the case of ambiguity. So generally, backing up, these clauses will be interpreted as any other clause. However, what you can see in the Darlington case is that little backdoor exit there. Where it's appropriate, the court can apply this clause contra proferentum, and we'll talk about that in just a moment. But even if there is no ambiguity on the face of the exemption clause, you do find the courts engaging in that nifty judicial two-step in order to somehow read down or limit the reach of the exemption clause fairly often. There are a number of ways that the court can read an exemption clause down without having to resort to the contra proferentum doctrine. And one of those is by saying that the conduct in question that is purportedly excluded, or liability for which is excluded, is outside the four corners of the contract, and we'll talk about that in just a moment. The other big one, is the contra proferentum rule, which again we'll talk about in just a moment. But even where you don't have those two main ways of getting around an exclusion clause or an exemption clause being engaged in by the court, you do often find a court, generally speaking, taking a quite a miserly, if you can call it that, approach to looking at the words that are contained in the exemption clause and reading them in a fairly strict fashion.
Now, I didn't want to have to do this, but you brought this on yourself.
A couple of examples will suffice here so that you get the flavour of what I'm talking about. In Insight Vacations and Young, you had a clause that purported to exempt liability for circumstances where the passenger occupies a motor coach seat fitted with a safety belt. It said that neither the operators nor their agents or cooperating organisations will be liable for any injury, illness or death, or for any damage or claims whatsoever. There was a personal injury that occurred in that case. The plaintiff was actually not sitting in her seat with the seatbelt. She was out of the seat getting something from the overhead rack.
Please, would you stop screaming? Damn!
And in that circumstance, the court said, sorry, but the actual exemption clause, the exclusion clause, only purported to cover the circumstance where the passenger was seated with the seatbelt on, and therefore, because she wasn't seated, the exclusion didn't apply, and the plaintiff could claim damages there. In the Wallace and Pratt case, you find a court doing something that they do on a fairly regular occasion, and that is construing an exemption clause that related to a warranty, strictly speaking, in its technical legal meaning as a warranty ban, not a condition, just a term of the contract. And in that case, the exemption clause stated that the seller gives no warranty express or implied as to the growth, description or any other matter of particular seed that was to be bought and sold, and you guessed it, the seed was a different variety than was anticipated, and the defendants purported to rely on this term excluding any warranty to avoid liability there. In that case, they said, hang on a minute, the exemption clause purported to exclude liability for warranties, and here the term that was at issue was a term implied by the Sale of Goods Act, and that term implied by the Sale of Goods Act was a condition, and therefore the condition was not excluded by the purported exemption clause because it was a condition, not a warranty. So fine distinction there. That shades into the nature of a court actually starting to apply the contra proferentum rule. There is a very similar case to the Wallace and Pratt case that we'll talk about in just a moment. So in terms of the contra proferentum rule, and yes, that is how it's spelled, it's a shorthand for the longer Latin phrase, which I'm not going to even attempt to say, blah, blah. But it basically means that the words of a written document are more forcefully construed against the person that's trying to insert them. And in this area of law, the person trying to insert the exemption clause is usually referred to as the profferens, because they are proffering a term that will ultimately, hopefully, benefit them. Technically, the contra proferentum rule is only applied when the clause itself on its face is ambiguous, and in such circumstances the court needs to resolve the ambiguity strictly against the profferens. Okay. However, we do have courts effectively engaging in contra proferentum like behaviour, as we saw in the Wallace and Pratt case, when you compare it to things like the IMCO case, which was a case of the contra proferentum rule being applied. So in that case, you had the vendor of some defective tractors trying to rely on an exemption clause, And what had happened was there was a warranty in the sale agreement that said that the goods would be free from defects for a year, and that the vendor's obligations under the warranty were limited to replacement of defective parts, and the warranty was expressly in lieu of all other warranties express or implied. So the seller of these defective tractors was purporting to exclude all other warranties express or implied. Much like the Wallace case, we had some sale of goods legislation that was at issue here in the New South Wales Court of Appeal, and it said that the condition that was imported into the contract via the sale of goods legislation continued in force because read strictly and contra proferentum, the written statement only replaced all other warranties express or implied. Okay, so there we have very similar case law. Again, just a couple of different examples to give you an idea of how the court does try and read down these kinds of clauses to perhaps allow remedies where they might otherwise be excluded. The Alex K case is kind of more of the same, although possibly a more helpful application of the contra proferentum rule for us, as the court really does step through things a little bit more carefully. And in that case, Alex K was a car hire company. They had insured their cars with an insurer, and unfortunately they hired a car to a rather dodgy fellow who then absconded with the car. They tried to claim under their insurance for the car, and the insurance company purported to rely on an exclusion clause excluding liability caused by any breach of contract, agreement or obligation. The reasoning was that the loss was caused by the breach of contract by the dodgy hiring party, and therefore they shouldn't have to pay. And in that case, Scholl J took a rather nice approach to the situation, and he said that the words used in this particular exemption clause were ambiguous, and there could be three meanings. The exclusion of liability for breach of contract could mean any breach by Alex K. It could mean a breach by third-party hirers, or it could mean any breach of the contract at all. And it specifically says, the judge specifically says in that case, because the least favourable option was option A, then it was limited to option A. So the exclusion only applied to breaches of contract by Alex K and not breaches by Alex K's hiring parties. And so there, a good example of a nice application of the contra proferentum rule. So that's one of the major ways that you will get around the exemption, exclusion, limitation clause that is purportedly applied by one of the parties. So we've seen the general attitude by the courts is simply to use ordinary principles of construction augmented by the contra proferentum rule in cases where there are identified ambiguities in the exemption or exclusion limitation clause itself. Although, as I said before, sometimes a court will just take a rather miserly approach. They may not call it the contra proferentum approach, but they may take a rather miserly approach in order to try and provide the plaintiff with some remedies and skirt around the edges of the exclusion. There have been particular nice questions, curly questions, interesting questions about whether or not you could exclude or limit, otherwise exempt liability for negligence, for fundamental breach, and for conduct outside the four corners of contractual obligations. So we just need to cover off these in order to complete our discussion of how courts will treat exemption clauses. In terms of negligence, there was a fairly long and protracted line of cases that got us to our present point. But there used to be some question about whether or not exemption clauses could extend to cover a party's own negligence. So effectively, you're concluding a contract, you are saying, yes, I'm going to perform my obligations, but I won't be liable for breach of the contract, including I won't be liable for my own negligent conduct. And the courts kind of took a fairly dim view of that kind of caper. And there was another question about whether or not you could say that the attempt to exclude liability for your own negligence was really an attempt to exclude liability for fundamental breach, and we'll talk about that in just a moment. The way the case law has evolved, really, since Davis and Pierce parking station, is that generally speaking, the clause will just be read according to its terms with general principles of construction. And if the clause itself is broad enough to exclude and apply to negligence, then, you know, so be it. The clause will exclude negligent conduct. And if a party wants to enter into a contract whereby the profferens purports to exclude their own negligent conduct, well, so be it. If that's what you're silly enough to do, that's what you were silly enough to do. There's no reason to necessarily read down a clause where it was plain and did extend to circumstances of negligence. So no real problem with excluding your own negligence nowadays. However, we've had a series of cases that have probably more vehemently fought the idea of excluding for fundamental breach. The whole notion of fundamental breach is inherently problematic, and you've got several cases in our own High Court. It's a British concept, and there was uncertainty for many, many, many years about whether or not we were going to import that into our law. Many, many cases saying, oh, really, this is a distinction without any distinction, really. You don't need to talk about fundamental terms in some vague way because we have the concept of essential terms here and conditions. The Luna Park case and the tramways advertising, Associated Newspapers and banks. These cases are effective, and these cases help us work out whether a term is an essential term of the contract. You don't need to then talk about this fluffy other notion of, well, okay, it might not be an essential term, but it might be fundamental to the contract in some way, such that breach of that term might still allow you to terminate. I noticed that Graw tends to suggest that fundamental breach was imported into our law via the Lorinda and Capalaba Park case, although you should note that that was only a two-judge joint judgment in the Lorinda case, and there were 3 other judges on that particular bench that did not engage with the whole notion of fundamental breach, and in fact kind of looked at it a bit askance, as if to say, you know, we really don't want to touch that hot potato here. So as I said, there was this question about, well, if you're going to breach a term that is so fundamental to the contract that effectively the whole point of the contract, the whole benefit of the contract would be lost, the kind of breach that goes to the root of the contract, can you really exclude liability for something as serious as that? And in Sydney Corporation and West, another High Court case, we had the court specifically saying that the question is one of interpretation, and it's not for the court to impose limits on what people can contract out of. So much in the way that the negligence cases evolve, so this whole notion of not being able to exclude a fundamental breach kind of evolved the same way. The court said, well, if you were silly enough, basically, to enter into a contract where very serious breaches are exempted by the profferends, then, you know, who are we to argue with that if it's very clear on its face? However, and I quite like this decision for the way it teaches us that there are many, many ways to peel a banana in judge land. And just because there was no way for the court to exclude the operation of that clause because it purported to cover a fundamental breach, the court said, well, hang on a minute, the circumstances of this case fall very neatly into another line of cases which are sometimes called the deviation cases or the four-corner cases, and for that reason the exemption clause in that particular situation had no operation. So what they said in relation to fundamental breach was certainly repeated in the TNT and Main Baker case, where they said there was no doctrine of nullifying an exemption clause due to fundamental breach, and that was again confirmed in the NISO Hawaii, Australia and Malaysian International Shipping case. So similar journey in terms of fundamental breach as for negligence. You can now exclude both if everything is clear, unambiguous, and the clause is broad enough to catch that kind of behaviour. And the last way that the courts will try and read down, get out of, skirt along the edges of an exclusion clause is by a doctrine sometimes called the Four Corners Doctrine, or probably more often called the deviation cases. And this is simply a little concept that says you can't exclude liability for acts done in a way that are not authorised or permitted by the four corners of the contract itself. So you can only exclude liability for things that can happen in the ordinary course of the contract as contemplated by the parties, four corners of their agreement. So in the Sydney Corporation and West case, which I was just talking about before, they said no, we can't get around this exclusion clause because of the whole notion of the fundamental breach issue, but we can get around this exclusion clause because it falls into the deviation cases. And in that case, the thief got the parking station to issue a duplicate ticket because he said, oh look, I'm sorry, I've lost my parking ticket, can you issue me another one so I can get my car out? Got the duplicate ticket, got the car out, sure, but it wasn't his car to take. The full court there held that that instance of exemption clause was purporting to exclude a fundamental term, and because it was a fundamental term of bailment to exercise care and return the goods, you couldn't have an exemption clause that applied to that conduct. Okay. However, as I said before, in the fundamental breach topic, the High Court said, no, it's a matter of interpretation here. The clause excludes negligence within the four corners of the contract. So that whole fundamental breach issue is gone. But here, the act of issuing a duplicate ticket is not something that was authorised by the contract itself, by the four corners of the contract. It was conduct outside, completely outside, the four corners of the contract. There was never any suggestion in the contract that, oh, if you lost your ticket, then we'll just, issue you a duplicate one. This was something completely outside the contract, and because it was unauthorised, not permitted by the contract itself, therefore the warrant or the exclusion clause could only apply to conduct that had occurred within the four corners of the document. Mendelssohn's case in the UK is something similar here. So Mendelssohn's case was a case where the fellow got out of the car and handed his keys to the crook that had said he couldn't lock his car. It was against car park rules for him to lock his car, that he had to hand over his keys. so that the attendant could park the car, and in fact the attendant stole all the goods that were in the back there, and something similar happened there. It was a deviation from the way that the contract was supposed to have been performed, and therefore not caught by the exclusion clause there. So they are the different ways that a court might treat an exemption clause, exclusion clause, limitation clause, in order to try and still provide some remedies where it deems it appropriate to do so. And here we come to the end of our discussions on the contents of a contract and exclusions. I hope this has all made some sense, and if not, please, as I always say, shoot me an email, send me a tweet, send me a post on Facebook, give me a call. But other than that, I hope to talk to you sometime soon in a Zoom. And until the next topic, thanks. Bye for now.